Today, we're going to tackle one of the most important questions in the entire legal world. What in the world is a duty of care? Now, I know it might sound a little technical, but trust me, this one simple idea is the key that unlocks pretty much every single claim for negligence.
So let me ask you this. If someone does something careless and you get hurt because of it, it seems obvious, right? You should be able to sue them, hold them responsible. But is it really that simple? Well, not quite. And here's the twist. Before a court even thinks about whether someone was being careless, it asks this really critical first question. It's a hurdle, a test that everyone has to pass. Did the person who hurt you actually owe you a legal duty to be careful in the first place? And that's what a duty of care is. It's the official legal obligation to be reasonably careful so you don't hurt other people. Think of it like a gatekeeper. If you can't prove that duty of care existed, the gate to your claim is slammed shut. End of story. You don't even get to make your argument. So here's our game plan. We'll start with the absolutely wild story of how a snail in a ginger beer bottle basically invented modern law. Then we'll see how the test for this whole duty thing got more and more complicated, especially for public bodies like the police. And finally, we'll land on where things stand today. So let's jump right in with one of the most famous cases in legal history. It all kicks off in a little cafe in Paisley, Scotland. And yeah, it really does involve a snail. This one single bizarre event created the entire modern law of negligence as we know it today. No joke. So get this. The facts of the case are just wild. Mrs. Donahue's friend buys her a bottle of ginger beer. She drinks some of it, and when she pours out the rest, out plops the decomposed remains of a snail. Ugh. She gets incredibly sick. But here's the legal problem. She didn't buy the drink herself. Her friend did. So she had no contract with the manufacturer. Back in 1932, that basically meant, sorry, you got no case. But then this happened. A judge, a guy named Lord Atkin, looked at this whole mess and came up with a completely revolutionary idea. This one sentence changed everything. He said, you know what? Let's forget about contracts for a second. Let's think about something much more basic. Who is your neighbor? So, who is this legal neighbor? It's not just the person who lives next door. Lord Atkin's brilliant idea was that it's anyone you could reasonably predict might be affected by what you do. So if you're a manufacturer bottling ginger beer, you should probably be thinking about the person who's actually going to drink it, right? And just like that, boom, the modern duty of care was born. Now, Lord Atkin's idea was beautifully simple, but you know how it is with the law? Things rarely stay simple. Over the next 80 years or so, the courts spent their time making it more and more complicated. It was like a legal pendulum, swinging from one extreme to the other. You can see that pendulum swing right here on this timeline. After the snail case in 32, things were pretty steady. Then, bam! In 1978, a case called Ann's blew the doors wide open. But the courts got nervous, and in 1990, they slammed those doors shut with a new case called Caparo, before finally finding a bit more balance in 2018. And this slide really shows you what I mean. The Ann's test was super expansive. It basically said, hey, if harm is foreseeable, we're going to assume there's a duty of care unless there's a very good reason not to. The result? A so-called litigation explosion. So the courts freaked out a bit and brought in the Caparo test, which was way more cautious. It flipped the script and put all the work on the person suing to prove 3 separate things. So here are the 3 hoops you had to jump through under Caparo whenever a totally new situation came up. First, foreseeability. Was the harm predictable? That's straight from our old friend Lord Atkin. Second, proximity. Was there a close enough relationship? And third, and this is the really tricky one, is it fair, just, and reasonable to impose a duty at all? Right, and it's that third step, fair, just, and reasonable, that causes all the headaches. This is where things get really complicated, especially when we're talking about suing a public body like the police. This is where the law has to zoom out and think about the big picture, about society as a whole. Because when you get right down to it, fair, just, and reasonable is just legal code for one word: policy. This is the moment where judges have to step back and ask, okay, forget these 2 people for a second. What would be the consequences for everyone if we create a new duty of care here? And this quote just hits the nail on the head. It comes from a really tragic case involving the last victim of the serial killer known as the Yorkshire Ripper. Her mother sued the police, arguing they were negligent in not catching him sooner. But the court said no. Why? Because they feared it would lead to defensive policing. Cops might become so scared of getting sued that they'd spend more time on paperwork than on actually catching criminals. And it isn't just about policing. Judges are constantly weighing all these big picture factors. They worry about opening the floodgates to an avalanche of new lawsuits. They think about whether making professionals liable will just make them too timid to do their jobs properly. They ask, should we spend taxpayer money on compensation or on, public services? It's a massive balancing act. So after this whole journey, from a snail in a bottle to the most serious criminal cases, where did the law finally end up? Well, a very recent case has brought a whole lot of much-needed clarity to this entire area.
And here it is, the big news from 2018. In a case called Robinson, the Supreme Court basically said, whoa, everybody hold on. You've been using that complicated 3-part Caparo test way too much. From now on, that test is only for situations the courts have never, ever seen before.
So what does that mean in the real world? Well, the rule now is way simpler. If the courts have seen the situation before, like a doctor and a patient or a driver and a pedestrian, they just follow the old decision. That's called precedent. The Robinson case also made it crystal clear that the police do owe a duty of care if their own actions directly cause you harm. They're not above the law. So that big, complex Caparo test, it's now the rare exception, not the rule. So, just to recap this whole roller coaster ride, we started with Lord Atkin's simple neighbor principle, which is still the foundation of everything. Then we shot over to the super wide ANS test, which has since been overruled. It's not good law anymore. And that led us to the cautious Caparo test, which, as we now know, is only for brand new, novel cases. What a journey, right? And when you boil it all down, that's what this is all about. The duty of care is a constant, incredibly difficult balancing act. On one side of the scale, you've got an individual's right to get justice when they've been harmed. And on the other, you've got the need for society to function properly without everyone being paralyzed by the fear of getting sued. Which leaves us with this final, really tough question. When you have a direct conflict between getting justice for one person and protecting the good of everyone else, how is the law supposed to choose? There's no easy answer, and it's a question the courts have to wrestle with every single day.